Hello friends, in the series on the income tax cases, today we will discuss a very important issue which has come up before the Honorable Rajasthan High Court, and the issue was that whether the assessing officer can impose a penalty for which the satisfaction has not been recorded by the assessing officer in the assessment order, and the second issue was that whether the Principal Commissioner of Income Tax has a power under section 263 to revise the assessment order to the extent that the assessing officer can change his satisfaction in the assessment order for levying a penalty under a different section which has not been already recorded in the original assessment order by the assessing officer. Both the pertinent issues have been taken up by the court in the case of Principal Commissioner of Income Tax versus Harish Jain, and this case is reported in 478 ITR at page number 727, and the date of the judgment is 3rd March 2025. In the present case, the assessment year involved are assessment year 12-13 to 2018-19, and when the assessment order was passed by the learned assessing officer, then in that assessment order he has recorded the satisfaction to levy the penalty under section 271AA(b). Section 271AA(b) talks about the penalty in cases of such cases. But after that, the assessing officer initiated the penalty under section 271AA(b), for which the satisfaction has been recorded in the assessment order, and for penalty under section 271 subsection 1 clause C also. And to support his initiation, the Principal Commissioner of Income Tax has also directed the AO to revise the order to the extent of recording the satisfaction to initiate the penalty under section 271 subsection 1 clause C. The assessing officer did the revision accordingly, for which the assessee filed the appeal before the tribunal. The tribunal said that the Principal Commissioner of Income Tax was not justified in revising the order to the extent of directing the AO to record the satisfaction in the assessment order for initiating the penalty under different section. The revenue challenged this order before the High Court, and when the court heard the matter, the court said that for levying penalty under section 271, first of all, it is mandatory for the assessing officer to record under which clause he wants to impose the penalty on the assessee, whether it is clause A, B, C or D. The court said that assessment and penalty proceedings are separate, and the court also said that recording of satisfaction is mandatory during the assessment proceedings, but the notice can be issued either during the assessment proceedings or after the assessment proceedings, but once the initiation of penalty is done, then the penalty order should be passed according to the time limits which are given under section 275. The court said that initiation of penalty proceedings by the assessing officer cannot be a substitute for recording the satisfaction for imposing the penalty in the assessment order, meaning thereby that recording of satisfaction for initiating the penalty or for imposing the penalty is a sine qua non for the assessing officer. The court said that order cannot be erroneous for non-recording of satisfaction in the assessment order, and the Principal Commissioner of Income Tax cannot direct the AO to record the satisfaction under a different section. In the present case, the revenue was pleading that it is a case of wrong mentioning of section, but the court said that in the present case it is not a case of recording of wrong section or mentioning of wrong section, but it is a case of non-recording of satisfaction for initiating the penalty proceedings in the assessment order. So the basis of initiating the penalty or imposing the penalty is not there, so the penalty proceeding should not be allowed to be continued. Friends, this case is very important because this case gives a very clear message that until and unless the satisfaction for initiating the penalty is recorded in the assessment order, the penalty cannot be imposed on the assessee. at the end of this video. Once again, I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Harish Jain, and this case is reported in 478 ITR at page number 727, and the date of the judgment is 3rd March 2025. Thank you, friends.